Hello aspirants, welcome to Spardha Line. We are going ahead with our session that is Complete Indian Polity through MCQ. And today's session we are going to discuss interstate relation as well as the emergency provision. So we'll begin with the interstate relations, and the first question itself is about the interstate relation, that is Article 262. So the statements are there. First statement, the Constitution provides that the Parliament may by law provides for the adjudication of any dispute or complaint relating to interstate river and river valleys. Second statement, the Constitution provides that neither the Supreme Court nor any other court shall exercise the jurisdiction in any interstate river water dispute. So let me know which statement is correct. Choose the correct option. Okay. And those who are comfortable in Kannada, they can read the Kannada. So we'll see which statement is correct here. If we see first statement, it says the Constitution provides that the Parliament, okay, so it means Constitution directs Parliament to make a law to provide for adjudication of any dispute or complaint relating to interstate river and river valleys. This Article 262 itself talks about the adjudication of interstate water dispute, and in this there is one provision that under the Article 262 that Parliament with the law they can adjudicate dispute or the complaint with respect to interstate river or the river valleys. So the first statement becomes correct here. Second statement, if we see, the Constitution provides neither the Supreme Court nor any court shall exercise the jurisdiction in interstate river water dispute. It's not a constitution, but the Constitution directed to Parliament. So it is the Parliament who has brought the law to tell that the Supreme Court or any other court will not have any jurisdiction with respect to interstate river water dispute. So when it comes to this word Constitution, it makes the statement wrong. So second statement is wrong. The only one statement is correct, that is first statement. So correct option is the A. Okay. So we'll move towards the next question. It is again about the interstate river water dispute. So with respect to this, first statement says that the river boards are established by central government to advise state on coordinated development of interstate rivers. Second statement, Parliament itself directly set up an ad hoc tribunal to adjudicate an interstate water dispute between the two or more states. Third statement, the decision of interstate water dispute tribunal is final and binding on the parties to the dispute. So let me know which statement is correct. You can choose the correct option. Last D option, I guess it is not visible, but it is 1, 2 and 3. So choose which one is the correct one. Okay, we'll see which one is the correct. Before going to this question, we'll see the brief background that we have seen the Article 262, which talks about the adjudication of interstate water dispute. Under this particular article, the Constitution has directed Parliament to make a law, and Parliament had made two laws. First law, it's about it made the River Board Act, and second act is that Parliament brought is Interstate River Dispute Act. Okay, so this first act, that River Board Act, this River Board Act, it empowers the central government to establish the river boards to see the development of the interstate rivers. Okay, and the central government, it establishes these boards on the on the advice of the state government, and in turn it advises the state government on the coordinated development of interstate river. So the first statement is correct. Second statement, Parliament itself directly set up an ad hoc tribunal. These ad hoc tribunals are first set up under this particular act, and it is not the Parliament but the central government. The central government establishes this ad hoc tribunal, and this particular ad hoc tribunal, they adjudicate on the interstate water dispute between two or more states. Okay, so second statement become wrong because it's not Parliament, it is the central government. Last one, the decision of interstate water dispute tribunal is final and binding on the parties. Yes, this is correct according to this particular law. So the correct option is the C, that 1 and 3 are correct. So currently if you see the interstate water dispute tribunal, there are currently 9 interstate water dispute tribunals. So if you see the particular in case of Karnataka, so Karnataka, let me know in comment section, Karnataka has the water dispute with which of the states, and in how many interstate water dispute tribunal Karnataka is one of the member. Okay, so we'll move towards the next question. It is again about the article 263. We all know article 263. It is about the interstate council. So first statement says the president can establish interstate council to promote coordination between the state and to serve the public interest. Second statement, the president can define the duties, organization and procedure of such council. Last statement, the function of the interstate council are complementary to the Supreme Court's jurisdiction under Article 131 regarding interstate dispute. So let me know which one is the correct here. Okay, we'll see which one is the correct. These all three statements are correct. Okay, so it is the president who will establish this interstate council, and this council primarily for the promote coordination between the states and to serve the public interest. So that's why the first statement is correct. Second statement also, the president the president is empowered to define the duties, organization and procedure of such a council, that is interstate council. So the second statement is also correct. Last statement, the functions of interstate councils are complementary to the Supreme Court's jurisdiction under Article 131 regarding interstate dispute. So when it comes to this Article 131, it is about the original jurisdiction of Supreme Court. When it comes to this original jurisdiction of Supreme Court, so we all know there are Supreme Court original jurisdiction. One of the case it extends to the, when it comes to the dispute between two states or the dispute between center and state. Here the Supreme Court's original jurisdiction extend. So according to Supreme Court itself, whatever the function this interstate council will perform, it will be complementary to the Supreme Court's original jurisdiction. Okay, so that's why the third statement is also correct. Correct option is the D, that D option is there. It says 1, 2 and 3 are correct. So D is the correct option here. So we'll move towards the next question. Okay, it is again about the article 261. So first statement is the legislative and executive act of any state government shall receive full faith credit throughout the territory of India. Second statement, the parliament may by law prescribe the manner in which public acts, records, judicial proceedings of one state shall be proved and given effect to the another state. Last statement, the final judgment and the order of civil courts in any part of India are capable of execution anywhere within the territory of India. So let me know which one is the correct here. Okay, so when it comes to this article 261, it says the full faith, okay, full faith and credit to the public act, the public records, and public judicial, the judicial proceedings. Okay, so now when it comes to the public act, when it comes to this particular public act, it includes, this particular public act includes the legislative as well as executive acts. So when it comes to public act, these are nothing but executive and legislative act. When it comes to these records that are made by the public servant while executing their duties. And last came to judicial proceeding. It is the judicial proceeding, either be it civil court or criminal courts. Okay, so in neutral, when you read without considering article 361, 261, the judicial proceeding, it involves the civil proceeding as well as the criminal proceeding. So now if you see the statements, the first statement talks, the legislative and executive act of any state government shall receive the full faith and credit throughout the territory of India. Yes, because of this, yesterday when we were discussing the central state relation, that time one aspect we saw that when it comes to legislative relation or legislative power of the state legislature, if there are sufficient nexus between the object, okay, and the state, then that state legislature's law extend to that particular object. So the territorial, extraterritorial legislative power of the state legislature, and if there is, in case of there is sufficient nexus, then it can be enforced there. So for that only, that aspect only, the legislative and executive act of any state government shall receive full faith and credit to the throughout territory of India. Means if you are belongs to one state and the act, legislative or executive act of other state will receive the full faith and credit in that your particular state. It doesn't mean it is not brought by the your state government. Okay, so this is the meaning of this particular statement, and this statement is correct. Second statement, the parliament may by law prescribe the manner in which, okay, public act, record, judicial proceeding of one state shall be proved and given effect to another state. So yes, the parliament will make law because it's talking about the relation between two states. So okay, there need to be neutral and third person to make a law in this regard, because if both states are making, there is possibility of biasness. So to avoid this, obviously the constitution will empower the parliament. So the second statement becomes correct, and the parliament will also determine the manner or its extent when it comes to the legislative and executive acts of any state, okay, when they are enforcing in other state. So that time the manner and the extent will be decided by the parliament. Okay, last statement, the final judgment or order of civil court any part of India are capable of execution anywhere within the territory of India. Yes, when it comes to civil courts, the proceedings of civil courts will get full faith and credit to throughout the territory of India, but it not applies when it comes to the criminal proceedings. Okay, it applies only to the civil proceedings, okay, not criminal proceedings. So that's why the third statement is also correct. So correct option is the D. 1, 2 and 3 all are correct. So we'll see the next question. So it talks about the, it again asking you to consider the article 301. So it is about the power of parliament and state legislature. So first statement says the parliament may in public interest give the preference to one state over another or impose restriction on the interstate trade. Okay, second statement, the state legislature may impose reasonable restriction on the trade commerce with that state, but only with the prior sanction of the president. Third statement, the state legislature may impose discriminatory taxes on goods imported from the other state. Let me know which one is the correct here. Okay, we'll see. First, when it comes to this article 301, it is about the interstate trade, commerce and intercourse. And this interstate trade, commerce and intercourse shall be free. It shall be free throughout the territory of India. Okay, so in this regard, there are some certain statements that we'll see. The parliament may in public interest give preference to one state over another to impose restriction on interstate trade. Yes, because in public interest or in exceptional situation like scarcity of goods are there, then parliament can give the preference to one state over the other, and also it is empowered to impose restriction on interstate trade. Okay, if you all are aware about the Essential Commodity Act. The Essential Commodity Act, it is nothing but extension or the this particular act brought by parliament to give effect to the provision of this article 301. Okay, second statement, the state legislature may impose reasonable restriction on trade commerce with the state, okay, with that state, but only with the prior sanction of president. Yes, okay, in case of there is a scarcity of good within the state, so that time the state legislature of concerned state can impose the reasonable restriction on trade commerce with the other state, and but for that it need to take the prior sanction of the president. So second statement is correct. Last statement, the state legislature may impose discriminatory tax on goods imported from the other state. This is not right. Okay, for example, if the state A it producing pen, okay, and for that production it is imposing 5% tax. Okay, there is state B, it is imposing the pen, and now this pen manufactured in state B, and now this state particular wants to export it to state A. So that time this particular state A cannot impose the 10% tax on that. So this pen manufactured in that state A and the state B, they both should be subscribed for the equal tax. There should not be discriminatory tax when it comes to the same goods. Okay, so the last statement is wrong. So correct option is A, that 1 and 2 are correct. So next statement we'll see, next question we'll see. It is about the zonal council. So first statement, the zonal council are established by the act of parliament to promote interstate cooperation and coordination. Second statement, the union minister nominated by president act as chairman of each zonal council. Last statement, the president may nominate member from the state as the vice chairman of the council in case of where the council of minister does not exist in that state. Okay, it is talking or it is imagining the case of precedent rule. So let me know which one is the correct here. Okay, so now question is neutral here. It is talking about zonal council. So if you are aware about, there are the two types of zonal council. Okay, there is one zonal council for the northeast and another there are the I get 5 zonal council for the all over or the remaining India, okay, or mainland India. So when it comes to this 5 zonal council, it is established by State Reorganization Act in 1956. Okay, but when it comes to Northeast Council, it is established by Northeast Council Act 1971. Okay, so it means the zonal council are established by the act of parliament, be it a Northeast Zonal Council or the mainland zonal council, be it a northern zonal council, central zonal council or the southern zonal council. They are established by act and they are primarily to promote interstate cooperation and coordination. So statement become correct. Now when it comes to second statement, the union minister nominated by president act as the chairman of each zonal council. Yes, in Lakshmikant DPC it is talks about the home minister. Okay, home minister of India, he will be the chairman of the zonal council. Okay, it is just because of the president recommended, but if you see the document of State Reorganization Act, okay, that in that document it says that union minister nominated by president to that zonal council will act as a chairman of the zonal council. So this is the text in the State Reorganization Act, but it is not explicitly says that only the home minister can become the chairman of the zonal council. Okay, so remember this one fact. Last statement, UPSC president may nominate member from the state as a vice chairman of the council in case of where the council of minister does not exist in that state. This also correct. Okay, in case of president rule, the council of minister of particular state is suspended, so that time the president can nominate the any member from that state to act as a vice chairman, because when it comes to zonal council, okay, this particular zonal council chairman will be the union minister and vice chairman will be the CM of the member states. Okay, the member state, and this will be through the rotation. Now suppose there are 4 states A, B, C, D. Okay, now suppose this year the CM of the A state A will become the vice chairman, but there is the president rule in particular this state A, so that time the president will nominate the member from this state A, and that person, the member or that nominated member will act as a vice chairman for that council, and this is the exact text that given in State Reorganization Act. Okay, so that's why you need to remember this. So the correct answer is D. These all 3 are correct here. Okay, so we'll move towards the next question. It is again about the zonal council. So it says that all zonal council are established under the State Reorganization Act 1956. Hope this is clear because just I explained you. The Union Home Minister act as ex officio chairman, and the CM of the member states act as a vice chairman by rotation for the Northeast Zonal Council. Okay. Third statement, the Northeastern Council is responsible for formulating unified coordinated regional plan, reviewing the security and public order measures taken by the member state. So let me know in comment what is the correct answer. Okay, this one, choose this one. D is the 2 and 3. Okay, this is not given in the M. Lakshmikan. You can take a guess here. Okay, so just we have discussed when it comes to the zonal council. Okay, 2 zonal council are there. When first zonal, there are 5 zonal council for mainland India, and there is 1 zonal council for the northeastern states. Okay, so when it comes to mainland India, zonal council for mainland India, these are established by the State Reorganization Act, but the zonal council for northeastern India, it is established by Northeast Zonal Council Act of 1971. So then all zonal council are not established by the State Reorganization Act. So this is first statement is wrong. Second statement, the Union Home Minister act as ex officio chairman and same of the member of state act as a vice chairman by rotation for the Northeastern Zonal Council. No, when it comes to Northeastern Zonal Council, the Northeastern Zonal Council Act, it says that the particular Northeast Zonal Council Act, it clearly says that the Home Minister, the Union Home Minister, this Union Home Minister will be ex officio chairman of the Northeast Zonal Council, but same not mentioned in the State Reorganization Act to establish a zonal council for mainland India, but it is explicitly mentioned in the Northeastern Zonal Council that Home Minister, Union Home Minister should be ex officio chairman. And when it comes to vice chairman, this particular provision for the mainland zonal council, okay, the CM of a member state as a vice chairman by rotation. But when it comes to Northeast Zonal Council, it is not a CM, it will be the Minister of Donor. Okay, the donor, the Ministry for Development of Northeastern region. So this minister responsible for this particular ministry will be vice chairman, so not the CM of the particular state. So the second statement is also wrong here. Last one, the Northeast Council is responsible for formulating unified coordinated regional plan and reviewing the security and public order measures taken by the member state. This is the correct. Okay, so the correct option is the C, that 3 only is correct. Now hope you got the difference between the mainland zonal council and the northeastern zonal council, and there is one change when it comes to the Northeast Zonal Council. Okay, remember this, UPSC, KPCS, okay, or KE might ask question in this regard. Now next question, From here, we'll see the emergency provisions. So first statement is the emergency provisions are incorporated to safeguard the sovereignty, unity, integrity of India, protect the constitution and its political system. Second, during the emergency, the central government become all powerful and state comes under its complete control. Last statement, the emergency can be proclaimed on grounds of war, armed rebellion, failure of constitutional machinery, and financial instability. Okay, quite easy question. D option is the 1, 2, and 3. Okay, let me know which one is the correct here. Okay, easy question, will not spend much time here. So when it comes to emergency provision, these are incorporated in Article 352 to Article 360, and these are incorporated in Constitution in the part, what part? It is 18th, part 18th of the Constitution. These two aspect, this is the very important because already in 2024 they have asked this kind of question. So remember the parts for the major constitutional provision at least. Okay, so there are some rationale, and one of this rationale is the behind inclusion of emergency provision. One is the to protect or the safeguard sovereignty, unity, integrity of India and the constitution of India and the political system of India. So the statement is correct. This is the one of the rationale of the emergency provision. Okay. Second, during the emergency, central government become all powerful and state comes under its complete control. Yes, this we'll see through the MCQ how exactly the central government become all powerful and state goes complete control of the union government. So this we'll see through the MCQ, but second statement is correct here. Last statement, the emergency can be proclaimed on grounds of war, armed rebellion. So okay, these are the correct. There is emergency given in Article 352. It is called national emergency, and this emergency included based on the grounds of war and armed rebellion. Second, when it comes to failure of constitutional machinery, it is the Article 356, that is nothing but the precedent rule. Last is a financial instability, that is financial emergency, that is comes under Article 360. Okay, so these all grounds are correct. So correct option is the D, that 1, 2, 3 all are correct. Okay, so quite easy for the refreshing. I just put this question. Next question we'll see. It is from here we'll see your knowledge. So first statement is about Article 352. First statement says the president can proclaim national emergency when the security of India or any part of it is threatened by the war, external aggression, or the armed rebellion. Second, the national emergency can be declared even before its actual occurrence of such threat. Last statement, the president may issue separate proclamation on the grounds of war, external aggression, or the armed rebellion. So let me know which one is the correct here. Okay, we'll see which one is the correct. First is that the president can proclaim national emergency when security of India or any part of India is threatened by the war, external aggression, armed rebellion. This is correct. Okay, these are the three grounds: war, external aggression, and the armed rebellion. Okay, before declaring national emergency under Article 352. Second, the national emergency can be declared even before actual occurrence of such a threat. Yes, obviously we'll not wait till the enemy nation attacks on us. Before that, we'll prepare. So for that, this provision is included. Last, the president may issue separate proclamation on the grounds of war, external aggression, armed rebellion. Yes, this is correct, and this particular provision included in Article 38th Constitutional Amendment 1975. This particular 38th Constitutional Amendment give the president to issue the separate proclamation on grounds of war, external aggression, armed rebellion. Because in 75, the government has imposed national emergency. So before that, we know that 1971, we went with war with Pakistan, and it ultimately led to liberation of Bangladesh. So when we started war with Pakistan, that time there was already one emergency declared, and this was declared based on the war and external aggression. But when it comes to 1975, there was internal disturbance. Okay, previously there was not armed rebellion, there was word internal disturbance. Okay, there was widespread protest against the corruption, the inflation in country. Okay, so that's why this particular amendment made to declare the one more emergency in 1975. So in 1975, government came with 38th Constitutional Amendment Act. It empowered the president to declare the separate proclamation. Okay, so war, external aggression, armed rebellion. So already there was emergency ongoing based on the war and external aggression. But in 75, another emergency declared, this based on the armed rebellion. Previously it was the internal disturbance. Okay, so for that only, keeping this in mind that they wanted to declare one more emergency, so for that they brought this particular constitutional amendment. Okay, so there is always logical flow. So if you are remembering or revising, or if you know these logical flows or the logical developments happened, then only it will be easy to remember. Okay, so this statement is also correct. So correct option is the D, that 1, 2, 3 are all statements are correct here. Next we'll move towards the next question. It is 44th Constitutional Amendment Act. So what are the safeguards that introduced by the 44th Constitutional Amendment Act? Okay, so you know the 42nd Constitutional Amendment. 42nd Constitutional Amendment, it is known as what it is known as? It is known as mini constitution. Okay, it is known as mini constitution. This particular mini constitution has brought the several changes in the constitution. And 44th Constitution, when the Janata Party government came to remove this, what are the damages done under Article 40, the 42nd Constitutional Amendment. They brought 44th Constitutional Amendment, and they have introduced many safeguards. Okay, they effectively curtail the power of Parliament as well as the government when it comes to declaring emergency and other like arbitrary action. On the arbitrary action, they put some restriction. Okay, so in this context, question is asking, what are the safeguards when it comes to the national emergency that are declared or introduced by the 44th Constitutional Amendment? First is the term armed rebellion was substituted for internal disturbance as a ground for national emergency. Second, it provided different proclamation of emergency on different grounds. Third one, it made the written recommendation of cabinet mandatory for declaring the national emergency. Last one, it made declaration of national emergency immune from the judicial review. Okay, so let me know which one is the correct option here. Okay, we'll see. The first statement just we have seen, it is correct because the 44th Constitutional Amendment, it is substituted internal disturbance with armed rebellion, because internal disturbance, it is very vague word and it is subjected to interpretation. Even the protests are happening in country, government might interpret it as an internal disturbance and they might declare the national emergency. To avoid this kind of situation, the 44th Constitutional Amendment brought the word that armed rebellion. Okay, this particular armed rebellion that brought, so there should be armed rebellion. Okay, then government can declare the national emergency. Second statement, it provided different proclamation of emergency different ground. Just we have seen, it was the 38th Constitutional Amendment. This particular amendment empowered government to declare the national emergency on the different grounds. Third one, it made the written recommendation of cabinet mandatory for declaring national emergency. Yes. Okay, so the written recommendation of cabinet, it is required, and the only article, that article 352, which mentions the cabinet, it is not council of minister, but it is the written recommendation of the cabinet ministry. Last statement, it made declaration of national emergency immune from judicial review. No, it actually made by the 42nd Constitutional Amendment, that it made the declaration of national emergency immune from the judicial review, and this particular introduction, the provision inserted by the 42nd Constitutional Amendment, deleted by the 44th Constitutional Amendment. Later on also there was a Minerva Mills case. In this particular Minerva Mills case, also Supreme Court said that this particular provision is void. Okay, it is said that it is unconstitutional. So the correct answer is the 1, 2 and 1 and 2. 2 only are correct. So option A is correct. The only 2 are the correct here. We'll see the next question. It is again national emergency. So it is about the final when it comes to approval and disapproval. So once approval by the parliament, national emergency continues for indefinite period. Second, the resolution approving proclamation of national emergency must be passed by the special majority in the both house of parliament. Okay. So let me know which one is the correct. Okay. First, if you see the once approved by parliament, national emergency continues for indefinite period. It is wrong. Okay, once approved by parliament, national emergency continues for 6 months. Okay, but it can be extended for the indefinite period, but the 6-month periodic approval needed by the parliament's periodic approval needed. Okay, and this particular provision introduced by the 44th. Before 44th, if once you declare national emergency, you can extend it for indefinite period. Second statement, the resolution approving proclamation of national emergency must be passed by special majority of both houses. Yes. Okay. When it comes to the when president declares national emergency, it need approval of, second step it is need approval of who? The parliament. Okay. So when after declaring national emergency by president, previously when originally in constitution the approval of parliament, it could have been taken in the within the 1 month. Okay. Okay, 1 month, but 42nd what it did, it made it 2 months. So the after declaration of president national emergency, the parliamentary approval can be taken within the 2 months, but this again said unconstitutional, it is reversed in 44th Constitutional Amendment. It again said that there should be parliamentary approval taken in within the 1 month. Next, after when it comes to approval, it must be 2/3 members. It must be by the present special majority, that 2/3 member present and voting. Okay, plus it must be the majority or the that is 260 to 272 when it comes to the Lok Sabha, and it is around the 123 to 4 when it comes to the Rajya Sabha. So this much member must wait. In addition to this, the 2/3 members present and voting must vote in favor of the approval. Okay. Originally, it was not simple special majority. Originally, when constitution came, originally it was the only simple majority. The 44th, the 44th constitution made introduce this provision of special majority. So the second statement is correct. Correct option is B, the 2 only. Okay. Next question. It's about the executive power of central and state under the constitution. So okay, in respect of subject enumerated in union list, parliament had exclusive wait 1 minute. Okay, this is I guess yesterday's question that we have solved. Those who are not seen the videos, I can go and watch this video where I have in detail I have discussed about the central state relation, financial relation, executive or administrative relations, as well as the legislative relation. So there I have discussed this question. You can watch that video. Next question. Consider the following statement regarding revocation of proclamation of national emergency under Article 352. Now it is about the revocation. Okay, means abolition or the taken of the national emergency. First statement, the proclamation of national emergency must be revoked by the president at any time by issuing subsequent proclamation. Okay. Second statement, the Lok Sabha has exclusive power to disapprove the continuation of emergency by the passing resolution. Last statement, the resolution of disapproval in the Lok Sabha must be passed by the special majority. Now let me know which one is the correct. Okay. I guess D option should be 1, 2 and 3. Okay. When it comes to first statement, it says the proclamation of emergency may be revoked by the president anytime by issuing subsequent proclamation. That's correct. Okay, president can bring the proclamation to revoke the national emergency after the declaring proclamation or imposing national emergency. So first statement is correct. Second, the Lok Sabha has exclusive power to disapprove continuation of emergency by passing resolution. Yes, and this particular provision introduced by the 44th constitutional amendment. Okay, so in this case, if president or the cabinet is not ready to revoke the proclamation of national emergency, that time Lok Sabha or the 1/10th member of the Lok Sabha, 1/10th member of Lok Sabha, this 1/10th member of Lok Sabha, they can give the written notice to the whom they will give, to the speaker. Okay, the speaker, the presiding officer of Lok Sabha, and this speaker within 14 days he will bring the, or he will invite the session of Lok Sabha, and in this session the whether to continue national emergency or disapprove, the voting will be done. And when comes to this disapproval, okay, this disapproval, last stage, when Lok Sabha will vote for the disapproval, that time it will not pass it by the special majority, but it will pass by the simple majority. Okay, and this is the one ideal condition introduced by the 44th constitutional amendment to reduce the dictatorship of the cabinet or the executives. So it is helping separation of power. Okay, so this is the one more aspect, and the one aspect you need to remember, it is about the, when it comes to the proclamation. Okay, proclamation approval, when it comes to proclamation of approval, that time both houses, okay, both houses means which one, Lok Sabha and Rajya Sabha, they both need to pass the proclamation of national emergency or approve with the special majority. So both houses need to vote it for with the special majority. But when it comes to revocation of this proclamation, when it comes to revocation, the only Lok Sabha or the Lok Sabha has exclusive power to revoke the national emergency, and this too with the simple majority. Okay, when 1/10th member of the Lok Sabha gives the notice to speaker calls meeting or the session of Lok Sabha within the 14 days, that time the Lok Sabha with the simple majority can revoke the, or the pass the resolution to revoke the national emergency. So these are the aspect when it comes to the, there is a difference when it comes to approval and the disapproval. Okay, so that you need to remember. We'll see the next question now. This statement, okay, same just we have discussed. Next one, again the, it is about the effect of national emergency, the effect of national emergency. So first statement says the center become empowered to issue executive direction to any state on any matter. Okay, second statement, the legislative power of the state continue but remain subject to overriding authority of parliament. Third statement, the direction of the center extend to all states, even those where emergency not in operation. Now let me know which one is the correct here. Okay. So when we see the first statement, the center becomes empowered to issue executive direction to any state on any matter. Yes, the any state. Okay, because when it comes to this state government, the state governments will not be suspended. They will be in operation, but they will be subjected to overriding power of the parliament or the central government. Central government can give any direction with regards when it comes to the executive aspects, okay, or executive area. Center can give the any direction. So first statement is correct. Center legislative power of the state continues but remains subject to overriding power of authority of parliament. Yes, because state legislative assembly or state legislative council, they will not be suspended, but it will be subjected to overriding power of parliament. So in this condition, that just we say when we seeing the rationals of a national emergency, that time when we have seen one statement, okay, the center becomes all powerful. So in that, nothing but it extend its ability to give direction to state in executive, legislative and financial matter becomes the overriding. Okay, it can give the overriding direction to the state in executive, financial as well as the legislative matters. So that time center or the parliament can make law on state subject also. So that's why the overriding authority of parliament. So second statement is also correct. Last statement, the direction of center extend to all state, even those where emergency is not operation. This is correct, and this is particularly introduced by the 42nd constitutional amendment, because we have seen what 38th amendment did. 38th amendment, it is given the parliament to establish power to president to declare emergency on different grounds, and this emergency can be restricted to particular area also. Okay, so when it comes to this restriction of area, the emergency is operation in state A, but the state B where emergency is not in operation, still the center becomes the all powerful for that state. Okay, means for state B also the center can give the direction when it comes to executive, legislative and the financial matter. Okay, so there are the three aspects. Now when it comes to executive, we have seen the center can give direction to all matters. When it comes to legislative matters, in case of national emergency, the parliament can make the law on the state subject also, and it has the overriding power. Even the the legislature of state has made the law, the parliament can bring one law and can override the state legislature. Okay, again, the length of parliament, the tenure of parliament or the state legislature, it can be extended for 1 year period. Okay, at a time 1 year period, for one year. After finishing 1 year, they can again extend for 1 year, but it is not indefinite, but only for the 1 year. Okay, last, when it comes to financial relation, whatever the transfer, okay, transfer of finance was there, transfer of finance from center to state, it will be suspended. Okay, when it comes to this laws, the parliament making laws on state subject, okay, validity will be 6 months after. Okay, when the emergency will be revoked, after that maximum 6 months that law can be in operation. But when it comes to financial relation, once president suspend the transfer of finance from the center to state, this extend to the end of financial year. Okay, not only after 6 months but end of the financial year. For example, our financial year, you all know that it starts from April to 1st April to March 30. Okay, so suppose there is emergency declared on 2nd of April and this emergency is revoked on 1st of May itself. Okay, so now in this case, when this particular period, okay, the 2nd April to 2nd April to 31st April, in this particular period, the parliament, whatever the parliament will make law, after the 1st May, it will be extended for the 6 month, maximum 6th month, means May, June, July, August, September, October, November. Okay, means 1st till 1st November, the law will be in operation. But when it comes to financial relation, it will be suspended till the 30th March, not for the 6th month. I hope you would have understood this. Okay, so the third statement is also correct. Correct option is the all three are correct here. Okay, we'll see the next question now. It again, the effect of national emergency on fundamental rights. So first statement, during the national emergency, fundamental rights under Article 90 are automatically suspended. The suspension of Article 19 applies only when emergency due to war and external aggression. Last one, the action taken under the emergency cannot be challenged even after it ends. Let me know which one is the correct here. Okay, we'll see one. When it comes to national emergency, again there are two articles, Article 358 and Article 359. These are the two important articles. When it comes to Article 358, it automatically suspends Article 19. Okay, it talks about only the 6 rights under Article 19, and this, when national emergency proclaimed under Article 352, there is no need to suspend the rights, fundamental rights under Article 19. It will be automatically suspended, and this particular provision mentioned in Article 358. But when it comes to the the fundamental rights other than Article 19, when it comes to these fundamental rights, there need to be order, the presidential order or the notification to suspend the fundamental rights other than Article 19. Okay, and okay, so this, for this logic, the first statement becomes correct. Okay, during national emergency, fundamental rights under Article 19 are automatically suspended. Second statement, suspension of Article 19 applies only when emergencies due to war, external aggression. This is correct, and this provision particularly introduced by the 44th Constitutional Amendment. This is one more safeguard introduced by 44th Constitutional Amendment, because Article 90 is crucial because it includes freedom of speech, expression, freedom of protest, your freedom of livelihood, okay, and freedom to movement. So these all the essential fundamental rights includes in Article 19. So it is the made very tough for the government to restrict your rights under Article 19, and this is done by the 44th Constitutional Amendment. So last statement, the action taken under the emergency cannot be challenged even it's after ends. Yes, so whatever the action taken under the emergency, okay, or the action are related to emergency, these will not be challenged even after the emergency ends. So this statement is correct. Correct option is the D. The 1, 2, 3 all are the correct here. Next question, again it's Article 359. So it says that Article 359, fundamental rights themselves not suspended, only their enforcement is suspended. Second statement, the suspension of enforcement can last for the entire duration of emergency or for the shorter respite period. Last one, the suspension of order may apply to the whole or only part of country. So it is talking about the second aspect of the suspension of fundamental rights that's mentioned under Article 359. So let me know which one is the correct here. Okay, so first statement is correct because under Article 359, fundamental right themselves not suspended, their enforcement is suspended. Fundamental right will still exist, but you cannot go to court for their enforcement. Okay, the enforcement or the fundamental right, it will be suspended, or remedies, that remedies given under Article 32, this Article 32 will be suspended. Okay, that is the crux here. Second statement, the suspension of enforcement can last for the entire duration of emergency or for the shorter respite period. Yes. The suspension of order may apply to the whole or any part of India. Yes. This everything will be mentioned in the presidential order, because we have seen that there are two aspects. One is Article 358. When 358 comes, Article 19 suspended automatically, but when it comes to 359, to suspension of fundamental rights other than Article 19, these, for that there need to be presidential order, and this particular presidential order will mention the duration of fundamental right and the scope of fundamental right, to what part this suspension will extend. Okay, it depends on the presidential order to what part and for what duration the fundamental rights will be suspended. So the second and third statement is also correct. Again, one more aspect, while suspending this particular fundamental rights under through the presidential order, it need approval of parliament. With the approval of parliament, then only they can suspend the fundamental rights, okay, under article 359. Okay, so next question, it says the consider following statement regarding 44th Constitution Amendment Act and its effect on article 359. Okay, so that there are safeguards introduced by article 359, 44th Constitution Amendment, okay, under article 359. It is talking about that. So first statement says that the fundamental rights guaranteed under article 20 and 21 remain enforceable even during the operation of national emergency. The laws and executive action taken during the emergency can be challenged in court for violating article 20 and 21. Now let me know which one is the correct here. Okay, so technically both statements are correct. The fundamental rights guaranteed under Article 2021 remain enforceable even during the operation of national emergency. This is safeguard introduced by the 44th Constitutional Amendment. Okay, it is restricted to arbitrary power of Parliament as well as the central government. Second, the laws and executive action taken during the emergency can be challenged if they are violating Article 20 and 21. Yes, but when the other laws which are related to emergency, they cannot be challenged, they can be protected. This is introduced in article the 44th Constitutional Amendment. But if these laws are violating article 2021, then these will be challenged in court of law. Okay, so this correct option is C. 1 and 2 are correct here. Next question, again it is about the national emergency. I am also tired. So it says that there are 3 emergencies have been proclaimed in India so far. Second, all 3 emergencies were proclaimed on the ground of external aggression. Last one, the Shah Commission was appointed to investigate emergency of 75 and it justified its proclamation. So let me know which one is the correct here. Okay, so we'll see there are 3 national emergencies has been proclaimed in India so far. Yes, first emergency was in 1962 after Indo-China Sino War, that is Chinese aggression. We declared first national emergency and it was declared based on the war or external aggression. Second emergency 1971 when the Pakistan attacked India, that is December 71, we declared emergency and that is because of the based on the ground of war and external aggression. Last one declared under article in 1975, that is for the internal disturbance. That time the internal disturbance word was present in constitution. After when 44th Constitutional Amendment came, it is replaced the internal disturbance with armed rebellion. Okay, so from that you can understand that only 2 emergencies that were declared based on the grounds of war. Third one emergency based on the it was the internal emergency or declared based on the grounds of internal disturbance or the armed rebellion in present context. So the second statement is wrong. Last one, the Shah Commission appointed to investigate emergency 75. This particular commission established by or the appointed by the Janata Party government and it is justified. It is not able to justify the proclamation. Okay, so third statement is also wrong. Correct option is the A. Only one is correct. We'll move towards the next question. This again from here we'll see the precedent rule, okay, or the state emergency, but constitution doesn't mention the word state emergency. So first statement says the article 356 and 365 provide constitutional basis for imposing precedent rule in a state. Second, the proclamation of precedent rule must be approved by the both houses of parliament within 2 months from its issuance. Third one, the once imposed, it continues for the 6 months and can be extended up to maximum 3 years with the periodic parliamentary approval. Let me know which one is the correct here. Okay. So when it comes to precedent rule, there are two provisions. Article 356, it talks about the failure of constitutional machinery. Second is Article 365, it talks about the if state fails to give effect to direction of state. Center has right to give direction state when it comes to the securing means of communication, schedule area, with regard to schedule area and security aspect. If center is not state is not complying with this central direction, then center is all empowered to impose the precedent rule based on the report given by the governor, or irrespective whether he gives report or not. So this first statement is correct here. Second statement, the proclamation of precedent rule must be approved by both houses of parliament within the 2 months. Yes, this is also correct. Last one, once imposed, it continues for 6 months and can be extended to maximum period 3 years per periodic parliament approval. This is also correct. Okay, so there is one catch here. Originally what was there, this 6-month period was there. Okay, though it continues for 6 months, but the 42nd amendment, what it did, it made it 1 year. So once approved, it will continue for 1 year. But again the 44th amendment came. 44th, it is reestablished this previous or the original condition, that is it will go for only 6 months, not for the 1 year. This is particular aspect abolished by the 44th constitutional amendment. So this is the one you need to remember. And maximum for 3 years you can extend it. Now there are the certain states. Punjab is there. Okay, J&K is there. So these two states where we have seen the national precedent rule more than the 5 years. For that, the parliament went for constitutional amendment, and under this amendment they introduced that beyond 3 years the precedent rule was allowed. Okay, so this statement is correct. Correct option is the D, that 1, 2, 3 all are correct here. Next statement we'll see. Next question, sorry. So what are the consequences of precedent rule under Article 356? The power of state legislature are exercised by the parliament. The president may suspend constitutional provision related to any body or any authority in a state. The parliament may delegate its power to make laws for the state to the president. Last one, the president may make a law confirming power and imposing duties on union or its office in that state. Okay, let me know which one is the correct. Quite tricky question it is. Okay, so when it comes to precedent rule, there are two aspects that you need to remember. Okay, so this precedent rule, now precedent rule has imposed. So precedent rule is imposed because of the hung assembly. So that time the state legislative assembly, it either will be suspended or it will be dissolved. Okay, so two cases are there, suspended and dissolution. So president, again there would be some parties will come together, the MLAs will come together and they can give the notice to the government or the application to government or president to restore the state legislative assembly and they can form the government. In second aspect, if there is no case, there is no like option remained, that time the president can dissolve this state legislative assembly. Now when it comes to suspension and dissolution, there are the two conditions. So in this regard, this particular question is there. So now if you see the first statement, it talks about the power of state legislature is exercised by the parliament. This is when state legislature is suspended, not dissolved. So when state legislature is suspended, that time president will tell that the power of state legislature will be exercised by parliament. This statement is correct. Second statement, the president may suspend constitutional provision related to anybody, any authority. Now this aspect, when state legislature is dissolved, that time president can suspend the constitutional provision to any body and authority in the state. This becomes correct. Now when state legislature is dissolved, that time parliament can delegate its power to make a law for the state to president. Yes, only when the state legislative assembly dissolved. Last, president may make a law conferring power or imposing duties on the union or its officer in that state. Yes, in case of state legislature is dissolved, that time president can do this. So now when it comes to these three aspects, it is when state legislative assembly is dissolved, and first is when state legislative assembly is suspended. Okay, so these are the aspects you need to remember. Now the correct option is the C, that all four are correct. C is their option, that all four statements are correct here. So next question we'll see. It is again Article 356 and President Rule. The satisfaction of President while proclaiming President Rule is subjected to judicial review. The Constitution mandates the President to impose President Rule in the case of hung assembly. Last, the Constitution authorizes the President to impose President Rule due to maladministration and corruption in that state. Let me know which one is the correct here. I guess these are visible. Okay, so when it comes to the satisfaction of president, there are two constitutional amendments. First is 38 constitutional amendment. It is said satisfaction of president, it is beyond judicial review, but there again 44th constitutional amendment came. It said that the satisfaction of president is not beyond a judicial review. Judicial review can be done if the president is imposing the president rule in particular state. Again, there is one case, well-known case is SR Bommai case. Okay, so the president rule was in Karnataka. The SR Bommai was the chief minister of Karnataka, and this particular case is known as SR Bommai case. In this particular case, Supreme Court said the satisfaction of president proclaiming president rule is subjected to judicial review. So statement is correct. The Constitution mandates president to impose president rule in case of hung assembly. No, the Constitution doesn't mandate. Constitution has envisaged only two situations. One is the failure of constitutional machinery under Article 356, and second is when state fails to give effect to direction given by the center under Article 365. So these are the only two circumstances that Constitution has envisaged. So this becomes the wrong. Last one, Constitution authorizes the president to impose president due to maladministration, corruption in the state. No, these are the unjustified or some circumstances that will be unjustified, that is given in Supreme Court in the SR Bommai case. Okay, those 2 and 3 is wrong. Correct option is the A, that only one is the correct here. Next question. Again, here we'll see the financial emergency. So few questions remained. It's about Article 360. It says that President can proclaim financial emergency if financial stability and credit of India or any part of there is threatened. Once approved by the both houses of Parliament, the financial emergency continues indefinite until it revoked. Last one, the resolution approving such proclamation is passed by the simple majority in both the houses. Last one, President may revoke the proclamation without approval of Parliament. Let me know which one is the correct here. Quite easy question. Okay, so here the president can proclaim financial emergency if the financial stability credit of India or any part of India is threatened. Yes, this is the ground mentioned in constitution itself under article 360. Second, the once approved by both houses of parliament, the financial emergency continues for independent until the it is revoked. Yes, there is no mention of periodic approval like national emergency where they need to take periodic approval after 6th month. There is no such condition mentioned when it comes to the financial emergency, and once it is approved, it can extend until it's revoked. Last one, the resolution approving such a proclamation passed by the simple majority. Yes, it is a simple majority. When it comes to national emergency, it is the special majority. But when it comes to the financial emergency, it is the simple majority. Last one, the president may revoke the proclamation of without approval of parliament. Yes, there is no need of parliament approval. President can revoke. Even national emergency also president can revoke without approval. But there is one safeguard introduced by 44 that when the Lok Sabha, the 1/10 members of Lok Sabha gives the notice to Speaker of the Lok Sabha, and they pass the resolution by revoking the the national emergency. That time it is on the president he must revoke the national emergency. But in case there is no such safeguard, it is solely depends on president and the council of minister. When they will want, they can revoke it. So the all four statements are correct. So the correct option is C. All four are correct here. Next statement, next question. It is again the consequences of financial emergency. It says the center can issue direction to the state regarding reduction of salaries and allowance of persons serving in connection with affairs of that state. Second one, the president may direct the state to reserve all money bill or other financial bill for his or her consideration before passage by the legislature. The president may issue direction for the reduction of salaries allowance of the judges of the Supreme Court and High Court. Let me know which one is the correct here. Okay, so here there is the aspect. Center can issue direction to the state regarding reduction salaries and allowance of person serving in connection of affairs of the state. Yes, it is correct. Second statement, the president may direct state to reserve money bill or other financial for his her consideration, not before but it is after. Okay, if somebody is following this initiative from first session, that time I told that why we lose marks. One aspect is lack of concentration. If somebody made this question wrong, because they might have skipped this word or they not have paid attention towards this word. Okay, so you must pay attention or you must read statements properly. Last statement, this statement becomes wrong, that's why. Last statement, president may issue direction for reduction of salaries, allowance of judges of Supreme Court as well as High Court. Yes, this is correct. So correct option is the B, sorry. Oh, only two are correct. Next question, I guess it is finished for today. So this is all wanted to discuss. I discuss about the interstate relation as well as the financial provision. Here we are finished this one. Next session I will come with the president, that is union executive. I'll see the president, vice president and the prime minister. For today I am stopping here. Thank you very much.